Thank you very much for coming out to this press conference. Dr. Kennedy Graham is releasing his members' bill today, and he can explain to you what it's about and why we're choosing today to do it. So, kia ora, thank you for coming.
Thank you, Materia, and my thanks to everybody for coming today in a rather quiet week. We are releasing my bill today, although it has been in the ballot twice and it hasn't yet been drawn, but with the luck of the Greens, we're totally confident it will emerge sooner or later. But independent of the ballot, it was important, we felt, to release the bill so that it could be open to public consideration and scrutiny. So let me first just convey to you the purpose of the bill. I know that there's a few pages of fairly dense material waxing under the title of explanatory note for you to go through, and then there's the attached bill itself. The purpose of the bill is twofold. There are two fundamental components to the bill. The first is to ensure that the use of force by our New Zealand troops overseas is always in conformity with the United Nations Charter. The second component of the bill, it's separate but obviously closely related, is that its political aim, in a very constructive way, is to protect our New Zealand leaders from external pressure to commit New Zealand troops overseas in situations that might be deemed to be illegal. The leaders of the world, which are always the major military powers, will take the lead and then look to smaller powers to participate. The distinction is whether it is UN authorized or whether it is coalitions of the willing outside UN authorization. The line is pretty fine sometimes, but it's critical. We will be under pressure. We have been under pressure in the past. The bill simply applies the same rules of international law today as has been the case for the last 63 years, since 1945. That is to say, an obligation not to commit aggression. There's no new constraint on the use of force by New Zealand under this bill. It requires a New Zealand leader to have legal advice on the legality of deployment of any New Zealand forces before a decision is made to deploy them overseas. They do this in a subliminal way for the last 50 years. What we're doing here in this bill is requiring that it be done in an explicit, reasoned, systematic, transparent way that is tabled in Parliament. It's important to make clear that once it is tabled, the role of members of Parliament is simply deliberative only. Parliament would not make the decision. The decision to deploy forces remains with the executive, but the legality of such a deployment would be open to debate and deliberation in the Parliament 7 days before an executive decision is made. We still retain the right to engage in our armed forces in self-defense at our own initiative, and we still retain the right to deploy our armed forces overseas as part of any authorized United Nations military operation. We have an obligation to protect our own boys overseas, the Wili Apiatas, extraordinary men and women who display remarkable courage and commitment overseas on behalf of this country. The motivation for this bill is not to charge at this New Zealand government or earlier New Zealand governments for any deployment of our people overseas. They've always been taken in good faith. This is for the future. This is to lay down standards for the future that we have not had in the past. We are not a democracy if any government of this country deploys troops in secret overseas, allegedly in the name of strengthening international security, and refuses to tell New Zealand citizens about it. I have the greatest respect for the SAS people and their and the greatest concern for their families. It does not follow that they have the right to total privacy because they have been deployed as SAS troops. That does not hold. So therefore, it would become mandatory that the deployment, and it does say, of any troops overseas, and that includes the SAS, would have to be tabled before Parliament to ensure the legality of the deployment itself. What they then do overseas is a separate issue, and we can all have our own ideas about that as well. I agree with you and your questions that the matter is complex. But as I said earlier, it is in full recognition of that complexity that we have to simply resolve with determination to proceed to make sure that the definitional dimension of a crime is tight enough and exhaustive enough to stand the scrutiny of judicial machinery, and that if a leader, I mean, you can have armies of lawyers arguing the toss, and you do, including in murder trials, as we have seen quite recently. That's why you have judges. We have judges to finally settle the matter, for better or worse. We're all human, we're all fallible. But we use force, and therefore we have to make sure that it's lawful. It is a quantum step forward to bring it into a domestic crime. I totally agree. But I firmly believe that the letter of the law is sufficiently robust. This bill would be creating new ground in one respect, borrowing from the monist tradition to set up a special office of the prosecutor based on the German situation, and for that matter, our own serious fraud office. So we actually have done it before. And the politics of our time are sufficient for us to proceed now. The normal doctrine of self-defense under Article 51 of the Charter allows for brief military operation to protect your nationals. And then it becomes a matter of judgment and ultimately, in this case, judicial interpretation as to whether that extends to how long, how far into a country, what they do when they're there, and whether they stay. Thank you very much for coming.